The next matter to come before the court is State versus Schell, and both sides are here, and it looks like they're ready to argue. And the court will remind counsel that each side has 15 minutes, and the appellant may reserve up to 5 minutes. And I didn't mention on the first case, but I should be mentioning on each of these cases, that we really prefer not to use victims' names, as well as the fact that whenever it's a child involved, we try definitely not to use their name and use either initial or just refer to it as to him or her as the child. So we're ready to proceed. When you are. Just tell me when to reserve time.
Thank you. And I would like to reserve 5 minutes as well.
Thank you.
Good morning, Your Honors. May it please the court, I'm Alan Medic. I am here on behalf of the defendant and appellant, Eric Schell, in this matter. This matter arises from what is essentially a neighbor fight on a fence line between Mr. Schell and his next door neighbor. In June of 2017, the neighbor removed some 30-odd foot of fence from Mr. Schell's yard and along the fence line. I think when you see the evidence, it will be clear that most of that fence that the neighbor removed was on Mr. Schell's property, even according to the line that was drawn by the neighbor himself. Then subsequently, that neighbor proceeded to put up a new privacy fence along the purported fence line in this case. At one point in that process, Mr. Schell touched, or as indicated in the brief, shook, or in the record, is alleged to have shook one of the posts that had been sunk into the ground, allegedly breaking it loose from the subterranean concrete that had been poured. And this resulted in claims and convictions of criminal trespass and criminal damaging for Mr. Schell. The issues raised on appeal are of insufficiency of evidence and manifest weight claims. When you see the photos presented and the evidence presented, the witnesses shown, it's clear that Mr. Schell and his neighbor don't like each other all that much, and that this has been a fight that's been going on for some time. But what is also clear is that the line that was drawn is not established in any way. There's a plumb line that is drawn that is pulled from the fence to the back corner. And even if that, and there's no surveyor present to testify to how that was drawn or how that was put in, the testimony of a police officer, I'm not sure how he would have knowledge of that line, or the victim himself are the only bases for establishing that.
Was Mr. Schell there when the surveyor did establish the line?
And I don't know that that is established. And what is clear is that even based on the line that is drawn, the photos presented in defense of this, the post that was touched is pulling that line out of place and pushing that, and is clearly, by the surveyor's line that is threaded, is pushed into Mr. Schell's property itself. That it is a trespass onto Mr. Schell's property. When he is touching it, he's on his own side of the property line as it's presented. We're not talking about, it's important to remember this is not a civil case. This is not a preponderance of the evidence claim. This is beyond a reasonable doubt that Mr. Schell acted recklessly in trespassing and in causing criminal damage to the post that was presented.
Counsel, the pictures that you're referring to in the video, was that prior to the time that he allegedly shook?
And those, I believe, were taken concurrently. All of this was happening within a day or two of each other. And Mr. Schell took those photos and attested to their time frame that they were at that time. And that
I guess
is
my
in the record.
question is, couldn't it be reasonably deducted that when he was violently shaking the post that he might have moved it into his own property?
I don't believe that they were taken after that. I think that there is no evidence to say that that's what happened. It's a state's case to prove here. And in that case, and you will see that it's it's clearly abutted and out of line, and I don't believe that was pulled, or there's any indication that was what was going on. And there's no.
How much, I'm sorry for interrupting again, but how much was in the record about the prior history between the parties?
And I believe that both Mr. Schell and the neighbor testified to their history and that they're not fond of each other, and that this has been an ongoing circumstance. And I believe even Mr. Malia, the officer who testified in that record, presented evidence that there was a conflict here.
So that the police had been called out on
Yes.
various occasions?
Yeah.
There was something in the brief regarding the neighbor having employed police officers
And
relative to this dispute. So my question is, I don't want to assume anything, but I'm guessing that the officer's testimony in this case was in the officer's official capacity and not as a person who was employed by the neighbor.
And I believe that there were complaints on both sides, and there's the questions that I don't want to get into as to who was responding, that Mr. Jones, there have been interactions between these parties for some time. That's not in the record, and I believe the officer was out there in regard to addressing a complaint.
Okay.
And making sure that I believe Officer Malia was there in an effort to keep the peace, and frankly. But the reality is that Mr. Schell and his fiancee at that time both testified that the line and the post were on his property, and that when he touched it. And I don't believe that there was any evidence. I don't think he intended, I believe he testified that he was not aware that he was causing damage to the subterranean concrete that was claimed for the criminal damages. And this is not a mere negligence case. It has to be shown of reckless for the criminal damage claim.
And counsel, I'm sorry if this was already discussed and I missed it. The surveyor's line went in how long before this incident?
Concurrently with, I
Okay.
believe it was drawn by the neighbor in order to, and I'm still not quite sure how we get to pulling out, and it's a matter for another day, but when you see the line, it's clear that the vast majority of the fence, all but 4 inches on a small, at most, on a small section of Mr. Schell's fence was pulled out entirely, and including vast majorities of fence that was on his property line. And that's clear from the surveyor. And yet, we end up here in a criminal case for Mr. Schell touching one post that may or may not have been an inch or 2 over the property line. And that's where we are here. And on that, we get to beyond a reasonable doubt for a reckless action and criminal trespass. And I don't think that they've proven the case. I don't think that there was sufficient evidence, and particularly having not presented any evidence to verify that what is a matter of less than inches in terms of what property line is where the trespass would commence. There is no surveyor to test the accuracy of that or how that was done, and only the self-serving testimony of the neighbor and an officer who is obviously a layperson regarding what the accuracy of that survey line would be. I understand that the jury can rely on what they want, but I don't believe on what was presented, a reasonable jury could find beyond a reasonable doubt that Mr. Schell was trespassing or caused criminal damage to the post here. And that I will hold my time for a while.
Thank you.
Good morning. Good morning, Your Honors. My name is Kirsten Smith, a legal intern for the state of Ohio. As an initial matter, I'd just like to address a statement Mr. Schell's counsel made about the prior fence that was in place before the one at issue today. That fence is not an issue in this appeal. This is a pretty straightforward case in which Mr. Schell's neighbor was installing a privacy fence minutes after the last fence post had been placed in police officer working on the construction process was made aware that it was damaged. He then viewed surveillance video in which he saw Mr. Schell reaching over onto Mr. Jones's property and violently shaking the fence post.
Counsel, let me ask you this. You said we're not here about the other fence, and I understand that because Mr. Jones was not charged with removing the other fence. However, it sounds like a very similar type of incident. So it sounds like there is a dispute between these two property owners as to where the boundary lines actually were in the properties. So considering this is not a civil case but a criminal case, isn't that something we can consider?
Well, what had happened with that fence prior to beginning the construction on the new fence?
Now, all this is in the record, correct?
Correct.
Okay, go ahead.
Mr. Jones testified that a surveyor came out, located the property line, and marked it by placing 2 stakes and running a string along that line. Officer Malia testified that that line was there, and he estimated that the original fence was approximately 6 inches onto Mr. Jones's property, and that it had to be removed so that the new fence could go in on the property line that had been marked by the surveyor. Mr. Schell's argument that the property line was in dispute is based on his personal disagreement with the surveyor's placement of the property line. At trial, he testified that he did not believe the surveyor found the correct pin when he marked the line. However, Mr. Schell is not a surveyor, he doesn't have any expertise in that field, and he did not provide any evidence in support of his argument that the property line was incorrectly marked.
Would you have to?
If his defense that the property line was in dispute, and that he's arguing it was incorrectly marked, his statements alone do not establish that the property line was incorrect. Officer Malia and Mr. Jones, on the other hand, testified that the line was there, that the fence post was on Mr. Jones' side of the property, and that Mr. Jones reached over and violently shook the post that was on Mr. Jones' property.
Was the officers and the neighbors' testimony limited to the line was there? Or did they also say something to support the fact that the line that was there was the actual property line?
Mr. Jones testified that before the fence, he had hired a company to construct the fence, and they would not begin construction until a surveyor came out and marked the property line, so they knew where to put it. And Mr. Jones testified that the surveyor did locate the property line and mark it, and that that line was there throughout this incident.
And what, was there any testimony, I know you said something about, I wasn't sure what you were talking about with the 6 inches.
Oh, right, that was with respect to the old fence prior to the one that was damaged. Officer Malia, he testified that he guessed the old fence was actually 6 inches onto Mr. Jones's property, and that's why it had to be removed.
But when you put in a fence, you can't just put it on the property line, right?
Mr. Jones and Officer Malia testified that they were aware that the fence had to go right on the property line. The actual posts and the structure of the fence had to be on Mr. Jones's property, but it could not be, for example, like a foot away from that property line. It had to be right on the property line.
And there was no test, that was just what the testimony was?
That was just what the testimony was, that it had to go on that property line.
See, because of putting up fences usually, you can't put them right on the property line, there has to be some clearance there because the property line is for both properties.
It's not clear, based on the record, of who said it had to be on this line, but the fence was up against the property line, but the post that was damaged was still on Mr. Jones's property.
Thank you.
Mr. Schell also argues that he did not commit a trespass because the fence post that he shook was actually on his property. In support at trial, Mr. Schell submitted the photo, which was Exhibit C. The photo is an extreme close-up of a wooden fence post leaning on a string. And as was discussed earlier, it's not clear when this photo was taken. I don't believe that was mentioned at trial. And because it is an extreme close-up, it's impossible to tell whether the post was being manipulated, whether it was being pushed onto that line. And furthermore, if it was taken after the fence post was damaged, the fence post was free-flopping and could have been leaning on the property line. Officer Malia and Mr. Jones, however, testified that the fence post was on Mr. Jones's property. So the fact that Mr. Schell submitted a single photo of a wooden post leaning against a string does not establish that the fence post was on his property. And therefore, the jury did not lose its way when it found that Mr. Schell trespassed when he shook the fence post.
Counsel, in response to Judge Hensel's question about Officer Malia, was he there, was he called out because of this, or was he already there because he was hired by Mr. Jones?
He was already there. Mr. Jones asked that officers from the police department be present because there was such a contentious relationship between Mr. Schell and Mr. Jones. Officer Malia was there just to ensure that things ran smoothly and that there was no further altercations between the two neighbors.
Okay, and so who was paying the officer?
Mr. Jones was paying the officer to be there just to work as security.
Was he on duty at the time? I'm just asking what the testimony is about his presence there. I'm sorry, I'm extrapolating into other things, but what was the testimony about the officer's reason for being there, and whether or not he was acting as an on-duty police officer?
He didn't specifically say, Officer Malia did not specifically say I was an on-duty police officer. However, he stated that he was there because his sheriff told him that he received a phone call that a man was putting up a fence post. He and his neighbor did not get along, and they wanted security, someone there, police officers, to make sure that nothing happened between these two.
And was there any testimony that the defendant here, appellant, knew that the officer was there prior to the time that he allegedly shook the fence?
Yes, there was. Officer Malia testified that he described Mr. Schell as behaving belligerently towards him. He had actually
To the officer?
To the officer. And Officer Malia had spoken to him prior to the incident. Mr. Schell was there throughout the entire process. He was actually constantly making sure that the fencing workers weren't stepping on his property, which further establishes that he knew where that property line was, and that he certainly wouldn't have allowed the fencing workers to put a fence post on his side of the property.
How, and I don't know we'll read the transcript obviously in great detail, but how in the world do you put a fence in without, if you're putting it on the property line, how would you not trespass on the other people's property? Because you can't just stick it in from this side, you have to make sure it's all the way around, and when you're pouring the concrete and so forth.
Well, it wasn't directly on, I guess it would be incorrect to say it was directly on the property
That's what
line.
I'm getting at.
It was up against the property line, so it was right at the edge of Mr. Jones's property.
Well, let me ask you this, is there testimony as to how far away it was from the property line?
As the new fence was?
Yes.
They just said it was right along the property line. There was no testimony as.
Can you see in the video the line, the string, and what posts are?
The video was actually not submitted at trial. It's unclear why that was. However, as I said before, Mr. Schell's photos, there's no way of telling when they were taken, and there's no context because it is such an up-close photo of a wooden stake post leaning against a string.
But the video that the officer reviewed, there was some testimony the officer reviewed a surveillance video, and that wasn't submitted at trial?
Correct. The video was not submitted at trial.
Just the testimony regarding what the video depicted?
Correct. The testimony of Officer Malia and Mr. Jones, who both watched the video and described Mr. Schell as violently shaking the post.
Okay, then I'm very confused, I'm sorry. So even though there was a video, the only evidence submitted was the officer's testimony of the video. There's no objection to that?
It's not on the record, so this is pure speculation when I
Oh,
say this.
that's okay. That's
But,
fine. No, you don't have to get into that, that's fine.
There's,
That's fine.
well, there is testimony that Mr. Schell was charged, I think, a month after this occurred. So it's just possible that the video no longer existed, or could have been written over, but as I said, it's unclear from the record. But essentially, the evidence was presented as to the property line. There was a video that Officer Malia and Mr. Jones testified that Mr. Schell reached over and violently shook the fence post.
And was that the only testimony about, let me rephrase the question. Nobody testified, I saw Mr. Schell violently shake the post. They only testified, I saw a video of Mr. Schell violently shaking the post. Is that correct?
Correct.
Okay.
In addition to Mr. Schell being present in the area where the last fence post was placed, the fact that when Officer Malia went over to the fence post, he noted the gap in the concrete and that it was free-flopping. He hadn't heard any of the fencing workers say, hey, we screwed this last post up, we need to fix it, and none of the other fence posts resembled the one that had been damaged. So when viewed in a light most favorable to the city, the evidence establishes that Mr. Schell knowingly harmed Mr. Jones's fence post by violently shaking it, and Mr. Jones did not give Mr. Schell consent to touch the fence post.
Is this your first argument?
Yes.
You're doing a great job. Now, I want to ask you another question, though. You said viewing the evidence in a light most favorable to the state. What if we don't view the evidence in a light most favorable to the state? Because the second argument is manifest weight.
Well, the manifest weight, the question is whether the jury clearly lost its way and created such a manifest miscarriage of justice that the conviction must be reversed. In this case, there was obviously conflicting testimony as to whether or not the fence post was touched or not touched or violently shook. And a conviction isn't against the manifest weight simply because the jury chose to believe the prosecution's witnesses over Mr. Schell's version of the events. So, unless there are further questions, I would ask this court to overrule both Mr. Schell's assignments of error and affirm the judgment of the trial court.
Thank you. You have 5 minutes remaining.
Thank you. In response to the statements by the city's prosecutor here, first, and I believe you touched on this, it is not Mr. Schell's burden to establish where the property line is. It is the state's burden to establish every element of the offense here beyond a reasonable doubt. And it was incumbent upon them to establish that Mr. Schell had trespassed on the property. And it was their burden to demonstrate where that property line was in order to establish a trespass if that was a claim against Mr. Schell. To the question of whether the property line was, the fence was right on the property line, and I researched, and I was trial counsel on this as well. There is no setback order or requirement in Lakemore, and I believe that this property, and this is part of the issue, is I believe that this fence line was absolutely intended to be right on the property line.
So you're saying there was no evidence presented of any setbacks or anything
No,
like that?
there was no,
And
and I
the
believe
testimony
that
was that it was on the property
the
line?
testimony was that that thread was to be, that plumb line was to be on the property line, and that's where we are here today and why we're here right now, and I would dispute that even as to an insufficiency claim. And viewing that evidence in light most favorable to the state, that the burden of beyond reasonable doubt could be reasonably met by the jury here. And then that is indicated in the testimony even as presented here, that she stated Officer Malia guessed that that property line was accurate. Mr. Jones's testimony is, I think, inherently self-serving. And again,
And I'm interrupting, I know, and I
Feel free.
apologize, but I'm just having a hard time with this concept here.
yes,
And if I'd known about the no setback requirements, I would have asked the state. But I just don't understand the property line, how is it just one person's property line, if there's no setbacks?
that is an excellent question. And it is an issue at dispute between these neighbors and you know, this is there's a law just built for litigation. unfortunately, that is what we have. That right now we're dealing with a matter of millimeters, and that's an impossible. I'm sorry.
Do they have requirements of fence permits? Is there testimony about fence permits in this record?
And I am unclear.
Okay.
I believe that they, and what I'm also unclear on is that how they could pull out under this rule the entirety of fence. And I know that state has stated that's not an issue here, but I think you're correct that this is a huge concern, that they pulled out a significant amount of fence that was clearly on Mr. Schell's property. And Mr. Jones removed that physically to his property and subsequently destroyed it. And how that happens, and then Mr. Schell is tagged here with criminal damaging, criminal trespass, is a little beyond me. But no, the video is not presented, and may have been objected to in chambers. I'm not sure if it's objected to on the record. I believe that my position would be that that's a question of weight, not necessarily admissibility. I think you can talk about what you saw. It's not a hearsay issue so much as are you really gonna, when you could have seen the video. That was I believe it was an issue with the state. It was not running, just to clarify that for the record. And so I think it should be given the weight that it is due. But I don't think that not having the video, not able to clarify these things, I think works against the state. That they do not have a clear indication as to where this fence line was, and that there was an actual trespass, let alone a reckless trespass or a reckless damage, or knowing trespass.
No one from the fence company testified, no one from the surveyor
No.
company testified?
No, the only testimony was Mr. Jones, on the part of the state, Mr. Jones and Mr. Millian, Officer Millian. And then in defense, Mr. Schell and his fiancee, Ms. Grimes, testified as to their personal effect. And again, they're not merely statements by my client. There was photo evidence. I know what they've said about the closeness of the photo. There are also long shots of where that line was drawn and how that was to be there. And I'll leave that to your review.
You're at 7 seconds. by the
Thank
way.
you. Well, I very much appreciate your time.
Thank you.
Thank you for your
Thank you.
consideration.